Okay, thanks everyone. Thanks for joining us this morning for the latest in our Everything You Need to Know series, covering key employment law topics. Um, Today we're going to be covering social media in the workplace, everything you need to know about different aspects of that and how that plays into um, dealing with your workplaces, your employees, and the challenges that can grow up, and also how we deal with those. So yeah, that's what we're going to be covering today. Now, the issue that we'll be covering, or we'll be going into detail on, are how we can set rules and standards in the workplace for employee social media use. We'll be covering how to deal with bullying, harassment of or by employees online. Obviously, that's more and more common these days and can have and does often have connections to work and the workplace. We'll be covering the role of digital and online evidence in HR processes. That is very, very common these days. Screenshots and social media messages becoming part of investigations of disciplinary matters. So that includes in relation to disciplinaries, grievances, sickness management, that kind of thing. And we'll also be covering uh, the questions around who actually owns employees' professional social media profiles and accounts and the contacts that are made on those. And so hopefully, yeah, as I say, we'll be covering quite a lot of things, and hopefully that will help you considering social media issues in your own workplaces. Um, Obviously, the increasing use of social media presents both benefits and risks for employers and employees, hence covering these topics today. Clearly, the ability to connect with others, create networks, communicate quickly to a wide but also quite targeted audience sometimes can enormously benefit organizations when it's used positively, whether that's marketing or collaboration between colleagues. It can be hugely beneficial. However, many of those same features of social media sites can also create significant problems or risks for employers when the use of social media by employees, or particularly former employees, is not necessarily in the organization's best interests. Clearly, that will be most applicable if there are kind of controversial or offensive comments that are made, retweeted, or shared, particularly if they um, go viral and reach a mass audience. Now, as is a theme with many of these topics that we cover on these in this webinar series, many of the potential employment problems arising in respect of the use of social media, they're not really new employment problems from a legal perspective. Um, they're, they're much of the same things we consider in other contexts. However, they do arise in, I'd say, a relatively new context. It's obviously not that new. It's quite a common part of everyday life, but it's still applying that kind of newish, relatively new context to um, the existing or the application of existing employment laws and cases. And that's not always an obvious thing, or it's not always intuitive how that might play out. So, for example, issues that can arise, such as whether employers have protectable interests in business connections made on social media accounts. Um, what can employers do to minimize reputational risks as a result of employees making comments online, particularly where those are disparaging about colleagues or the organization or its clients? Questions around whether employees can be fairly dismissed or disciplined for comments that they make on personal social media accounts or profiles, and whether employers can monitor social media use for recruitment or other purposes. Just before I pass over to Julie to take us through how we might look at setting rules and standards for employee social media use, just for ease, I just wanted to kind of define what we're talking about with social media in this context, because clearly it's always changing, as we were saying before we started today. New platforms pop up all the time or become more popular at different points. And clearly there's no strict legal definition of what would be included in social media. That can make it difficult to, and Julie will come on to this, but that can make it difficult to cover absolutely everything in policies and procedures, as it is constantly changing. So these things need to be kept under review. But generally, it's going to mean internet-based applications, which people use on computers, tablets, smartphones, etc. Connect, keep in touch, interact socially. to market themselves or businesses by creating and sharing content. It could be text messages, they could be photographs, videos, and clearly there's a wide range of different sites, as we say, that this could include. So really today we're talking about some of the most obvious ones like Facebook, Twitter, LinkedIn, Instagram. But as things change and develop, new types of sites, new mechanisms will become more relevant. So that's what we're talking about today, and I'm just going to pass over now to Julie to take us through how we may go about setting rules and standards for social media use by employees.
Thanks, Gareth. So I don't think any of you will be surprised by the starting place, and that's really, if you're wanting to set rules and standards, you would have a social media policy. ACAS recommends that all organisations have a social media policy, and that should set out the guidelines for use of social media, obviously by their employees, including what is and is not acceptable behaviour at work, including when using the internet, emails, smartphones, and networking sites. Now, the things that it indicates that the policies should obviously give very clear guidance for employees on what they can and cannot say about the organisation, and be clear about the distinction between business and private use of social media. If limited private use is allowed in the workplace, then it should be clear what that means exactly, and of course, any limits on that. ACAS recommends that your social media policy should be agreed between the employer and staff and unions or staff representatives. I personally, I think, and Gareth, I would imagine, we're not quite so sure about that. I think it's really more of a commercial decision. I don't think it's necessary to agree the content, but it certainly would be useful, I think, to be aware of how your employees are using social media. So, for instance, I don't think there's any point in writing screeds and screeds of detail on personal use if you know that your employees are perhaps a bit older, or not necessarily, but that they're not bothered about tweeting in their lunch hour, they're not following anybody on Insta or whatever. So knowing your audience obviously is relevant, but it's ultimately up to you as the employer as to what you want the rules and regulations to be. Again, ACAS recommend that your employees don't feel gagged. I mean, again, I think it depends in what your employees are doing, what they're employed to do, and how much of an interaction they're maybe having on social media to represent your brand and your business. But certainly they should feel protected against online bullying, which we'll come on to in more detail later, and highlight that the organisation wants to protect its reputation. And that's obviously a key aim of a social media policy. So obviously a social media policy should be tailored to meet particular needs of your organisation, and should also be consistent with your other policies, for instance, on harassment, equality, and disciplinary issues, data protection. So they should be consistent across all. A social media policy should certainly explain what social media activities it covers. For example, if it covers activity on a personal social media account, where that activity may have an impact on the employment relationship. So some people would maybe post pictures of themselves in a uniform, or make it very clear where they work. And it's sometimes, you know, the two worlds will collide, and you're perfectly entitled to restrict an employee's right to represent you effectively, even in their personal accounts. We'll come on to that in a bit more detail later. But it's obviously about finding that balance. Organisations should obviously clearly explain that their social media policies are really there to protect the employer's reputation and prevent the employee from making disparaging comments about the organisation or other colleagues or customers online. And employees should be requested not to represent their personal views as being those of the organisation. In fact, some employees are asked to put a personal disclaimer to say, my views are my views alone and do not represent my employer, if there's an indication of who their employer is. And also, you can request that employees set up certain privacy settings on their social media accounts to restrict who can see their comments. Again, if it could impact on your business. A social media policy should explain the kind of consequences to an employee of making derogatory statements or of taking other problematic action online, obviously making it clear that disciplinary action could follow up to and including dismissal for very egregious flouting of any rules. And also, if you can have training in respect of your expectations and your standards, that's also useful. I mentioned the kind of private and public collide. We've actually got a very recently decided employment tribunal case, and that was Webb against London Underground. So Ms. Webb was dismissed for posting offensive comments about George Floyd and the Black Lives Matter movement on her private Facebook page. But her Facebook page did, however, list London Underground as her employer, and many of her Facebook friends were colleagues, London Underground staff. And the posts that she made were captioned and then circulated more widely on Twitter. And colleagues complained about her posts, and they also came to the attention of the Commissioner for Transport for London. So obviously there was a clear reputational impact on the organisation. So the Employment Tribunal did determine that it was acceptable for Ms. Webb to have been dismissed over these posts, even though she had obviously argued that she'd made them in her private life and on a private Facebook page. And that she therefore had the human right, the right to privacy. And the fact that the EAT upheld it was largely due to the fact that she regularly reposted content, interacted with people who were not friends in the Facebook sense, and was aware of and in fact encouraged and welcomed the fact that her friends routinely then reposted her content. So she knew it was going out to a much wider audience. And crucially, London Underground had a very thorough social media policy which made it clear that private posts on sites like Facebook were at risk of wider circulation and that disciplinary action may be taken if any of these posts were then inconsistent with its policy and potentially could cause reputational damage. But it wasn't just the reputational damage, it was also the fact that it was there was a potential discriminatory element and colleagues were offended by what Ms. Webb had posted. So ultimately, London Underground, with a robust social media policy, was able to defeat the challenge to the fact that she had been dismissed on the basis of a seemingly private Facebook page and posts made on it. So I'll pass you back to Gareth, and he's going to talk about social media accounts.
Thanks, Julie. Yeah, that case is quite an interesting one, really, because, well, it feels pretty common sense, I suppose, in terms of what most people would think. You know, those kind of comments being published online, and it reflecting on the company. It's fairly common sense. But what I find quite interesting about it is you always get this argument, and we're going to touch on it as we go through the session. But you always get this argument about, well, you know, that's my private account. It was for me and my friends, that type of thing. And really, this idea that flinging stuff online and expecting some sort of privacy to be there it's a non-starter really these days. Everyone knows that things can be picked up and they can go much wider than you initially intended. So I find that quite interesting because you always see that defense, and I've not really encountered it really working. But yeah, we're gonna touch on that shortly when we look at other rights in respect of social media use. Yeah, just moving over on to different types of social media accounts that your employees may be involved in, and I'm meaning here not necessarily the platforms, but in terms of how they are presented. So easy really if I give some examples and we go through. For example, an employer's social media account, so an account that's in the employer's company name or brand name. Clearly, they will be managed by often by someone in-house. Um, it could be outsourced, but often is done in-house by an employee. Um, and just yeah, I'm just going to cover now sort of how we can manage that from an employment law point of view. So, whenever a company uses a social media account to increase brand awareness or that kind of thing, and the account's created or managed by an employee or employees in the course of their employment, it's important that any social media policy is clear in terms of how that account is to be used. So you may want to look at having some specific sections of that policy that cover the employer's social media accounts. So explaining sort of the value of that account, what it's used for, and what it's trying to achieve. Outline who it belongs to and the rights that the um, employer has. An important practical thing that I see quite often, particularly when employment relationships break down, is making sure the employer has access to those accounts, the logins and passwords that may be held by an individual. You know, they need to be held centrally or by the company itself. So if that person changes, we're not locked out of those accounts. Um, you might want to be clear in terms of what the appropriate use of that account might be. So whether that's um, ensuring there's no breach of confidentiality for the information that's shared. So us, for example, as a law firm, if we're at MLP, if we're doing some social media activity, um, and we want to post some pictures, we don't necessarily want to be posting, you know, I was dealing with this really controversial matter for one of my clients today, and it involved this and this. Now, you can be breaching client confidentiality if you start talking about things like that. So you'll want to have clear rules about what can and can't be shared. It's fairly obvious in our context, but in other contexts, it may be less easy to define. Um, and clearly, you'll also want to make sure that you're including certain rules about um, whether you're going to comment on things like politics or news stories and avoiding breaches of copyright, defamatory comments, things like that. And this can sometimes sit against the idea that social media marketing is creative and people take spotting opportunities to um, market their brand or their business based on kind of what's going on and what's topical online. But it can sometimes be useful just to have clear ground rules about the tone of the account, what we're going to be doing, how we're going to present ourselves, just so you don't fall into any difficulties. Um, and where client connections are critical to the business, or you may also want to consider including in the social media policy rules about any connections made on social media during the course of employment and who they belong to. Now, that's probably easier to define when we're talking about employer accounts, maybe a bit of a grayer area when we're talking about employees' own professional social media accounts. So accounts that are in their own name, but are professional accounts. They're not necessarily um, social and personal accounts. They are done for a professional purpose, but nevertheless, they're held in employees' names. That can be a bit of a grey area. So just moving on to those kind of profiles. Um, if this is going to be important to the business in terms of making sure it's clear who owns those accounts, clearly we're going to want to make sure that's covered in our social media policy. Um, and what is right for one business won't always be right for another. And you'll want to make sure you get that balance right. But if you do want to cover those kind of things, again, the social media policy is the most important thing. That can be particularly important, as I say, around connections that are made with business contacts on individual professional accounts during the course of employment. So we'll all probably be fairly familiar with, if this is relevant to our type of business, protecting contacts, protecting client relationships that are made during employment, and those being covered by things like post-termination restrictions in the employment contract. So restrictions really that would say after your employment, you can't solicit our clients, our customers that you were connected to or that you made during your employment with us. So you can't just jump over to a competitor and try and tap up all our clients. We're going to cover that in a restrictive covenant within the employment contract. And we're seeing it being increasingly common for there to be specific reference to these restrictions covering anything made online, any connections made online. Um, Not necessarily quite as easy to police in practice, but nevertheless, we're seeing more and more attempts for that to be covered. So employers, instead of just a social media policy, they may want to make sure that they are including anything like that if it's important to them in the initial employment contract, um, and maybe even in any sort of termination agreements, settlement agreements, things like that. If we're reaching an agreement for an employee when they leave the business, we want to be covering things like that if it's a crucial aspect for us. And again, looking at how employees may interact or manage online groups and accounts. Um, Sometimes, particularly on things like LinkedIn or Facebook, you can have groups that the company either participates in or which they are in control of and they use to kind of market their business. And again, you're going to want to make sure that that is covered in policies and in rules in the workplace. Um, Particularly where employees are responsible for managing that account. As we say internally, there's often someone that's in charge of managing that, and we just want to make sure that's covered in any policy. And we have seen cases where, um, for example, there was a case of Whitmar, which is where a company successfully applied for an interim injunction, so basically an order that prevents someone from doing something. So they applied successfully for an interim injunction, which prevented former employees from misappropriating, misusing confidential information, which included the use of 4 LinkedIn groups, which were managed by that employee. So because those were set up as a company page, a company group, there was a confidentiality information or confidentiality aspect to using that group, and it was possible for the company to protect its interests in those groups, and as I say, getting a court order to prevent people from using that and taking them over when they were owned um, by the company. Um, as I say as well, many employees have individual accounts, particularly on LinkedIn, which they use for work or professional purposes. Many employers actually encourage their employees to use them as a means of marketing themselves as well as the business. And by using social media, employees can create an easily accessible network of contacts. There can be uncertainty over what happens to lists of contacts. As I say, when employees change jobs, they leave the business. And what we might expect as an employer might not necessarily tally up with the expectations of the employees or even the actual network itself as to what they expect. Now, generally, the contacts in an individual's own LinkedIn network will be the private property of the account holder. And indeed, that, for example, on LinkedIn, the user agreement that people agree to when they sign up to accounts, they probably don't read it, but it does state this, that the account holder does own that account and any contacts that are there within it. However, just because that's what it says in the LinkedIn agreement doesn't necessarily mean that there aren't things that employers can do, or doesn't necessarily mean that if challenged through the courts, etc., that different findings might be made. And therefore, there may be some situations where the contact details could be considered the property of the employer. And relevant factors when deciding who owns those contact details are likely to include whether the network and the contacts were made and the relationships arose during the course of business, where those connections are made and the relationships arise during time when, in essence, the employee is being paid by their employer, it's much more likely that you can make an argument to say, well, we were paying you to make those connections, we were paying you to connect with those people, whether that's online or in real life, and therefore we do have a legitimate ownership in those. Also, things will depend on the time that's spent, as I say, during working time, and the precise nature of the information that's contained in those networks. But we see that a lot. We see that connection between, sorry, that conflict between, well, LinkedIn says that these accounts belong to me, these connections belong to me, and the employer saying, well, actually, we don't agree with that. Look at our policy, look at our contracts, look at the work you were doing and when you were making those connections. Um, And as I briefly mentioned earlier, in light of the risks regarding social media connections to clients and the uncertainty as to the employer's ability to protect its position by relying just on the general law or user agreements, employees who are concerned about this, about the ownership of their contacts, the breaches of their confidentiality following the termination of employment, do really want to be making sure that they're at least addressing that within employment contracts, including potentially obligations that require employees to disconnect or unlink from employers, clients, and connections on social media when their employment terminates. Now, a lot of people might say, well, not really in practice, what difference is that going to make? I could disconnect, an employee could disconnect everybody and then receive invitations to reconnect very quickly afterwards. How are you going to police that? But nevertheless, they can be useful things to kind of set the framework of what we expect, and should there be any losses that are caused by that, it does give us something to rely upon. And as I say, you might want to prohibit reconnection during a reasonable limited period of time. You know, we often talk about restricted periods of 6 to 12 months, so you may want to look at preventing reconnection during those times to keep it reasonable. And again, as well as in the employment contracts, any settlement agreements that might be prepared, particularly when they're resolving a dispute between employer and employee, we're seeing it more and more common that they include obligations around how that's going to be dealt with online, whether that's disconnecting with people, announcements, obliging people to say that they have left someone's employment, anything like that is feasible, and we're seeing that more and more. So if that is the kind of thing that you think might be affecting your business, we can have a chat about it. It's certainly something that you want to be covering, as I say, in various different types of documents. I'm going to move over back to Julie now, who's going to take us through how we can deal with bullying online, cyberbullying, whatever you want to call it. Yeah, probably a bit more juicy than how we cover things in contracts, but nevertheless, it's just as important. So yeah, pass you back to Julie now, who's going to use phrases like trolling and cyberbullying. We're going to get very excited about that.
You're stealing my thunder, Gareth. Thank you. Yep, harassment and bullying, unfortunately, can take place obviously on social media websites just as much, in fact, probably increasingly more often as it does in real life. And when this occurs, as Gareth said, it's often colloquially referred to as cyberbullying or trolling. Employers should make it clear to employees, obviously, that online harassment and bullying will be treated as a disciplinary matter, just in the same way as it would treat behaviour of that kind if it occurred offline. So we have a recent case of a TEMO against Carphone Warehouse, and this was a case of harassment and discrimination which occurred in a social media context. And in that case, employees posted a status update on the claimant's Facebook page without his permission or knowledge. And the status update read, finally come out of the closet and I'm gay and proud. So the update was posted during working hours, and the claimant, who was not in fact gay, brought employment tribunal proceedings, and the employer was in fact found vicariously liable for the conduct which amounted to harassment related to sexual orientation. So the case not only demonstrates that obviously harassment can occur in an online context, but it can also extend to a particular characteristic that the individual doesn't actually have. So that's another example of discrimination where the person who is not in fact gay can still rely on that protected characteristic to take forward a claim of harassment. And again, I think that there was a lack of social media awareness, policies and training by the employers, so they were found vicariously liable for what the employees had done during working hours. So misconduct related to social media can obviously lead to problems for employers when it's used in an inappropriate way to make offensive comments or to do something offensive. So when employees is suspected to have behaved inappropriately or offensively online, or breached a social media policy, the employer can obviously commence disciplinary procedures, which ultimately could lead to dismissal. So again, no different from real life, if we want to call it real life misconduct, but there are certain features that are quite particular to social media. So examples of conduct that have arisen that can relate to social media and result in disciplinary action are using it for the purposes of bullying and harassment, as we've seen from the previous case. We've also had clients who've had issues with WhatsApp groups, which are created because individuals are colleagues. But again, the lines of social and work are blurred, and problematic conduct can occur, for instance, in that setting. Misconduct can also occur in social media, where, as Gareth has mentioned, they disclose confidential information, or they can write disparaging comments about the employer or colleagues, or indeed customers. Or writing or publishing offensive material which brings the employer's reputation into disrepute. So ACAS advises that any response by an employer to comments made on social networking sites should obviously be proportionate to what the person has done and the damage that the employer has actually suffered as a result, to allow the misconduct to be fair. To allow the disciplinary action to be fair. So in game retail against Smith, the EAT gave some guidance in social media cases, where they basically said, ultimately, obviously, that a dismissal for social media misconduct is the same as for any other misconduct. So you have to have a potentially fair reason, and it's got to be reasonable based on the particular facts. But specific factors to take into account from a social media context are: did they have a policy? Does the employer have a policy? What was the nature and seriousness of the alleged misuse? Does the person have any previous warnings for similar misconduct in the past? And was there actual damage done to, for instance, customer relationships or between colleagues? Some other factors that may be taken into account are, as again we touched on, was the social media account for personal use rather than work-related purposes? And whether a reasonable reader could rationally conclude that the comments made on social media did in fact damage the employer's reputation and were made on the employer's behalf. And ultimately, where the activity was conducted from, so were they sitting at home with a glass of wine at night, or were they doing it in their lunch break, or more importantly, during working hours? That's relevant. The impact of the conduct and the reasonableness of the employer's disapproval, the employee's position and role, and whether the name of the employer or names of customers have been mentioned in the post, and obviously whether there are mitigating factors. So many of the similar factors and characteristics that you would of course be taking into account in a normal disciplinary would feature. Obviously, did the employee apologise? Did they then remove the comment, or do they kind of stand by it? Looking at the individual's record of good behaviour, and whether or not the employee displayed contrition during the disciplinary process. So, as I say, lots of similar features that we're very familiar with. Sometimes I think employers are take a step back from social media misconduct because they think they maybe need extra evidence, or they have to do something slightly different. But the fact is, if they follow their normal procedures and take a sensible and reasonable approach, and take consideration of the usual things that they would take account of, then a dismissal or a disciplinary action short of dismissal should be considered fair in this context. And Gareth, I think you're going to mention the kind of crossover between human rights and privacy and freedom of expression.
Yeah, thanks, Julie. And just to finish off what you were saying there as well, one of the things I always find quite interesting is this idea of a lot of the times employers might see something online, and if they do want to tackle it, they'll jump to this idea of that they've been brought into disrepute by the actions of the employee. And many times that might be the case because the employee's account says where they work, and they actually mention, as you said before, Julia, they mention people by name or companies by name. But it's important not to just throw that kind of phrase around, without really thinking about it. That there have been cases. I was just trying to think. It wasn't it's sort of connected to social media. It's not directly a social media thing, but I remember there was a case a few years back. I think it was Asda, and they had some people messing about in the warehouse, and they were taking videos of themselves and putting it on YouTube. And Asda came down really hard on it, saying, "Well, you brought us into this disrepute. If our customers see that you're messing about in the warehouse, and it's going to reflect really badly on us." But when it came out in the tribunal case, it turned out like something like 8 people had seen the video, and they were all probably people in the workplace. And the only way it actually went wider and damaged their reputation was because they made a real big deal about it. Um, so it's just important not to just jump to the assumption that something's damaged your reputation when realistically it hasn't. Um, because if you're basing, say, a decision to dismiss on that, it's really going to fall down if then a tribunal looks at it and says, well, was your reputation really damaged by someone just doing something a bit silly? Could you not have said, yeah, you breached the policy, shouldn't really have done it, don't do it again, here's a first written warning sort of thing, versus acting like it's the most serious thing in the world and dismissing somebody for it. It's just always worth, and I thought that was a useful kind of summary of those things, really just to always bear that in mind, not just jump to assumptions about it. Have seen that happen, and yeah, it's just better to have
Yeah.
and some time reflecting on it. Um, yeah, and just moving on, just really briefly, because we did touch on it earlier, and the recent case that Julie mentioned, and there is a separate blog about this. I know you put a blog up, didn't you, Julie, or a post on ironically on your
On
LinkedIn
social
account,
media.
yeah, about this one. So check that out if you want a few more details. But um, in that web case, that kind of talked about this interaction between the right to privacy, which is essentially one of the key kind of human rights under the European Convention of Human Rights. Everyone's got a right to privacy. Everyone's also got a right to freedom of expression. Now, like anything else, those kind of rights they're not completely limitless, and it's not completely limitless in society to say everyone can say what they want, regardless of what impact that has on others. That other people have human rights that have to be balanced against that. So you often see in those cases that people will highlight, well, I'm allowed to say these things online. Those are my views, those are my opinions, and you can't take action against me just because I've done that. I have a right to freedom of expression to say that, or I have a right to privacy where you can't start interfering with things I say in private, or things like that. Um, and this case was that web case was quite an interesting example of that because, as I mentioned earlier, um, people do always cite that, and they will say things like, well, my Facebook account had privacy settings, and um, I only send them to my friends, and I've only got X number of friends, and they're not meant for wider sharing. um, and they try and say that, I had an expectation that only a small handful of friends would see that. And what you find consistently in these cases is that although a tribunal might take into account those things and take into account who you meant your audience to be and whether you put privacy settings on. So clearly, if someone says, "Look, I expected that to be a private message, but they've just posted it out there on without any privacy settings whatsoever," then that argument's not going to work. But if they do have some sort of settings, the tribunal might take that sort of thing into account. But they're also going to recognise, and they've consistently recognised, that regardless of those settings, once you've put something out there, you do lose control over that. So I think in that case, it was an example where people were screenshotting it. The people that saw it could screenshot it and then post it wider, even if the original post didn't get shared any wider. So it's always possible that once you put it out there, it, it, particularly if it's controversial, I suppose, that it's going to spread wider than you initially thought. Um, and therefore, that lack of control over information and people knowing that's how things were, can really undercut, as it did in this case, the argument that someone would reasonably expect a message to be private. And generally, particularly if that's coupled with um, content in a social media policy, it's going to be difficult for the employee to argue that although they do have those rights to privacy and rights to freedom of expression, is they're not going to override an employer's right to deal with that if they think it interferes with um, their own rights or protecting their own business and colleagues and things like that. So it's that lack of control really that can undercut those right to privacy arguments. And as I briefly just mentioned there, even if the right to privacy does apply and it is engaged, that's not, the carte blanche to the employee that they can say and do what they want, because an employer may still be able to justify interfering with that right or going against that right if it's proportionate in the circumstances. So, for example, if it's necessary to protect their reputation, legitimately necessary to protect it, or it's legitimately needed to protect colleagues or customers from things like discrimination or harassment or defamation and things like that. An employee could say, well, I've got the right to freedom of expression. Well, you do, but we've also got the right to um, interfere with that right if you're using that freedom of expression to discriminate against people or damage our business. So that's always an interesting area that gets discussed. So yeah, just wanted to touch on that briefly. I'm just going to pass over to Julie before we've got time for a few questions. I can see some questions have come in the chat as well. And Julie's just going to mention this thing that we see in pretty much every disciplinary or grievance process, the role of kind of digital and online evidence in those processes. So I'll just pass you back over to Julie now.
Thanks, Gareth. So we want to discuss the role of digital and online evidence in HR processes just quite briefly. As with non-social media examples of any of these processes, obviously evidence can come in a variety of forms. So you may be wanting to discipline an employee for something that they have done or have been reported to have done on social media. So what sort of evidence do you need? Well, as Gareth touched upon, it can be useful if you can have a screen grab or a screenshot of the offending or relevant posts. That's obviously very credible first-hand evidence, but it's not crucial. Just like pre-social media days, you could have misconduct where one person does or says something to another person. There were no witnesses, and ultimately you just have to rely on one person's word over the other, and therefore variable evidence from individuals, including the employee that's been affected, as to what they have seen or have been told about on someone else's social media account. Even if that's no longer accessible or has been deleted, is also useful. So having a physical, reference is great, and we know that there are all these features now that can make it very difficult to go back to a problematic post. Or disappearing messages, and obviously some of the social media sites are set up to remove photos or whatever after a certain period of time, but people obviously can screenshot them, and that can be very useful. But ultimately, a word of caution: if there has been an allegation against an employee, they must ultimately still be allowed to be fully informed as to what it is they're alleged to have done, and then have the opportunity to respond to any allegation about conduct that they have committed or alleged to have committed on social media. We have to check, was the employee really in Mystique when they were supposed to be at work? Or was it simply artistic license by the employee trying to appear more glamorous than they really are? And that is, in fact, a true story. We had a client who someone was allegedly absent due to ill health, but they were posting all these, fantastic pictures of them looking like they were having a great time. But actually, when the employer drilled down into it, the person really just wanted to kind of keep up with the Joneses in a social context and make it look like she was having a great time. Really, she was just at home with a cold. And so you've got to check it's not a Walter Mitty fantasy that actually the employee has done what they're alleged to have done. And that's a whistle-stop tour of social media. And I don't know if there are any questions, Gareth. You said you've seen a few come through.
Yeah, we got a good question. I'm just going to read it out because it's a good question in the chat box from Rehat. If a company doesn't have a policy, social media policy, would they still be okay to take action against an employee who posts inappropriate content that brings the company into disrepute? So in the absence of a policy, can we still take action? I'll let you go first, Julie, on that, and then I've got a couple of thoughts.
Yeah, I think the short answer is yes. Ultimately, policies are very useful, especially when you're getting into the nitty-gritty of a particular problem. But if misconduct is still misconduct potentially, and can still be challenged by the employer, even in the absence of a social media policy. And you would presumably have a disciplinary policy that would still describe doing things that would offend colleagues or potentially customers or clients, or again, the bringing the employer into disrepute. But ultimately, I would say yes. It's a social media policy is incredibly useful, but it's not. You're not obliged to have one before you take action.
Yeah, I think that's right. I think the general rule is going to be that if we want to set rules and standards and we want to make sure that um, if it's breached, the employees know what they've done and what they should have, shouldn't have done, then policies are always going to be the key thing. And that goes for anything really. It's a question we always ask, you know, so and so's done this. Well, they've breached our policy or they've done this. Can we take action? Well, the question we'll always ask is, what does it say in the policy? Are they aware of the policy? Is it clear? Does everyone know what it means? Do they know the consequences of breaching it? Um, so generally, it's always going to be a good idea to do that. But as Julie says, it doesn't necessarily prevent us. What it might do is it might potentially change the threshold of what action you take or what warrants action, because there might be certain things that are pretty clearly, if upheld, pretty clearly misconduct or gross misconduct. As Julie used the example, but bullying someone online, offensive comments, it may be pretty obvious that that's not the kind of thing that would be acceptable, and we can justify taking action on the basis of that. But if it's something slightly more minor, particularly if the employee's defense is, well, I didn't really realize I was doing anything wrong. Now that I know, I won't do it again. It can be trickier the onus might be on us as the employer to say, actually, you did know about this. It's in the policy. The policy was made available to you. Um, it's very, very clear. And so in the absence of that, it might just make it trickier for us. It's not completely black and white, but it's just one of those things where, yeah, having one's never going to do you any harm. It's going to help to have those conversations and set those standards, but the absence of them might just change the approach slightly into
Yeah.
what we can do.
So I think the less clear cut the misconduct is, the more useful a policy is, if that really makes sense. So that brings us back to the one about Webb, where she was arguing, well, it was on my private Facebook page, I wasn't at work, it wasn't in the course of my employment, and they were still ultimately able to take action because of their social media policy. But yes, as I say, if it's an email from one colleague to another or a text, it becomes a bit more straightforward, and social media policies probably not as necessary effectively, as Gareth was saying.
Do we have any more questions or examples or challenges that you faced that you'd like to discuss? Anything at all? Or yeah, please just jump in if you've got any questions. And if
I
not,
was
that
going
always means
to,
we've covered everything, doesn't it?
yeah, I
There's
was
a
going to
point.
mention a touch on it. Oh, Natasha, have you?
No apologies. I was supposed to be just taking off the mute there.
That's fine.
Question, you covered everything.
I was just going to talk about yeah, WhatsApp groups. Obviously, WhatsApp themselves, I don't know if you've heard their advertising very much sell the fact that it's end-to-end encryption, it's private, but you do see increasingly WhatsApp groups being used by colleagues. So the reason they have the WhatsApp group is because they're colleagues, but they do have a degree of socializing on them as well. And we have had clients who've had problems on these kind of WhatsApp groups. And again, with the help of policies, they've been able to take action because, you know, perhaps offensive text effectively or problematic comments are being made on the group. And although it's, as I say, allegedly private, because it has a relation to work, that they had to take action. And I think that was justified.
Yeah, and we've seen if that's caused a particular problem, which it has done for a few clients, where they've just said, we don't want you doing it. That is our, obviously, how you police it is a different question, but obviously if it goes wrong, then you'd be in a position of saying, well, we told you not to do this. It was clear, it was in our policy that we don't do work WhatsApp groups. We're not going to communicate with you on WhatsApp. You shouldn't be communicating with each other about work related things. Um, and that just protects the employer as well in terms of saying, well, we all know that in kind of harassment discrimination cases as the employer, we're liable, we're vicariously liable for what our employees do and say in the context of their employment. So if they're doing things on work WhatsApp groups that we certainly if we endorse the use of them, but even if we're just aware and we don't deal with it and it's got some sort of connection to work, we run the risk of, you know, one inappropriate meme being sent, um, you know, on the group, and then we're liable for that. So we have known clients who just say, look, we're not allowing that. Equally, other clients might say, well, now that's just going to curtail quite a lot of the creative interaction that we want. So you've then got to cover what's acceptable in those groups. Um, you know, and another example would be where we've had clients who are quite happy with those groups as long as people are using them properly. But then all of a sudden, someone uses it for a text to say, "Well, I'm not going to make it in today," and then notifying their sickness absence. Well, I thought that was where we discussed work-related things, but it doesn't get to the manager. It doesn't get, you know, in time. So just being clear about what that's being used for. And obviously, it's not always easy to think about every single scenario and cover every single scenario all the time. You're trying to cover and set these ground rules for what we expect as best we can, and it may adapt. And that's the beauty of our handbooks and our social media policies that they're not contractual. You can change them, they can adapt. Um, and if you do like an annual review at least, you're able to say, well, actually, there's a couple of scenarios that came up that weren't covered. We want to do that this time. So yeah, it's a changing thing. It's never going to stand still, but um, that can really help.
Yeah.
Any more questions from anyone?
Thanks a lot for that. It's just a quick question. It's a bit of a tricky one. In these social media policies, can we cover things like leaving reviews on Google and Glassdoor? Because they can be quite damaging to the company's reputation. And some of them can be anonymous, but some, if you know, if an employee, a current employee leaves a name, how can that be tackled? Would that be included in the social media policy?
Yeah, I'd say yeah, you can. There's nothing to stop you from doing that. Um, but it's probably only and probably one of the least effective kind of tools in your armory for doing that because um it's all about the cultural thing in that respect in terms of well someone puts yeah if it's outright defamatory it's insulting people and it's a different story but if it's just some negative feedback the business will have to think whether the best response is you've breached our policy there's a disciplinary on you know meeting or whether actually we're going to address that and we're going to say well did you talk about that internally first before you went there there's grievance policies there's and just trying to go about it from a slightly different angle. But we absolutely could cover those kind of things in policies generally. Little bit trickier to do with ex-employees, which are maybe the most likely to go on and say something, and they've just left. They're not happy, so they've just fired off a rant on Glassdoor. Then that might be trickier to police. That could be covered in some way by your post-termination restrictions. But again, can't cover absolutely everything, and you're probably limiting your restrictive covenants to, direct direct client contact and things like that. But in theory, all of that's possible. So what I'd say is, if that is something that you're tackling often and it's become a bit of a habit of people to do that, then yeah, you would be looking to cover it, and in a few different ways, the policy being just part of it.
You could also think about having a settlement agreement. Depends obviously on the terms of the individual leaving, and that doesn't necessarily always have to be a very expensive approach, but it can kind of lock down an employee a little bit more tightly if you think that there's going to be a problem thereafter. But there is obviously an expense involved in that, so you have to wait, you have to balance up the likelihood of them doing something problematic, and if they did, how damaging it actually would be before you started spending money on it. But it's definitely another tool when the employment relationship's ending and maybe not on great terms, to try and limit any damage after that.
Yeah, that's right. I mean, in those settlement agreements, they would, as standard, really include comments that say that we won't, neither party will make negative or derogatory comments about the other, and that's covered as a standard. We just had a follow-up question in the chat from Paul, just saying, surely the company's not untouchable. Can you not say anything negative about the company on social media if it's honest and true? Yeah, I don't think that's a completely valid point, Paul, because things like Glassdoor reviews, if we're looking in that context, then unless the employee is specifically tied down, as you say, in like a settlement agreement, to not make any derogatory comment, whether genuine or otherwise, then there is a right to say these things. If it is an opinion or a fair, I don't want to stray too much into that defamation because it's not my expertise, but obviously there is a right to say certain things. And it's always that balance, a company trying to protect its reputation and versus people being allowed to actually say what they want. And that's why a fair policy or a fair social media policy is not going to want to come across as ACAS recommend, gagging people, stopping them from saying anything at all. And it's going to want to be limited to, look, it can't be things that are offensive, outright insulting or the harassing or the bullying people, that kind of thing. And that's really what I was getting at with the comment as well with Rehat, where you're saying, okay, would a company's response always want to be clamping down really hard with tough disciplinary action, dismissing people, warning people that speak out? Culturally, you're going to create a bit of a problem with that actually, hang on, you're not open to any feedback, you're not open to any improvement, any constructive criticism. It's going too far the other direction. So you're always going to want to strike that balance culturally as well. But I think you're right to mention that they're not necessarily untouchable, but it's where you're trying to. I'm more thinking, when we're talking here, we're more thinking about those times when people are insulting and offending each other online, and we're open to harassment and discrimination claims as an employer, or where they're slagging off the company and slagging off customers, and we're saying, well, actually, hang on, that's damaging us as a business. It's not a fair comment. It's really doing some damage, and it's vindictive in some way. So those are the kind of scenarios that are more typical that we're covering today. But yeah, I think you're absolutely right. It's always a balance to be struck. A few people having to drop out. No problem. A few people having to drop out because, as I say, we are getting to our time, and they're probably worried about the toss at Headingley and whether we're going to bat or ball, and I understand that. completely. So yeah, if there's any more questions, we do have time. Otherwise, yeah, if you want to pick it up offline, want to get in touch about anything, just give us a shout. Yeah, we can have a look at any social media policies, anything like that. We can have chats offline if you've got any particular concerns. Yeah, please do get in touch. Brilliant.
Thank
Okay,
you.
thanks everyone. Thanks for joining us.
Thanks.
Cheers.
Thank you.
Take care. Thank
Take
you.
care, everyone. Thanks a lot.
Bye.
Cheers. Sorry I was late. I lost an hour this morning.
Oh, don't worry, Sam. It'll be on.
I'll catch up on the video, yeah.
Yeah, it's on the library, so you'll be able to. And I know Liz is away as well, so she'll be able to dive in and read
Yeah.
that as well, and listen to that as well.
Good stuff.
Brilliant.
All
Cheers,
right,
Simon.
catch you later. Cheers.
Cheers. See you.
Thank you.